Thank you, Mr. Chairman. Director, right now you're working on a draft resource management plan, RMP, for BLM lands in North Dakota. On that, you put out a preferred alternative that we have serious concerns about. Myself, Senator Kramer, Representative Armstrong sent a letter to you expressing those concerns, and I'd like Mr. Chairman to ask unanimous consent to make that letter a part of the record. Mr. Chairman?
Without objection.
Thank you. Essentially, this preferred alternative would close off new leasing to 45% of potential federal oil and gas acreage, and it would close off new leasing to 95% of federal coal acreage. Now, it's important to understand that in the grasslands, the BLM lands in North Dakota, you have a checkerboard issue. So it's a split estate ownership. So in a lot of cases where the federal government may own the surface acreage, they don't own the minerals. Those are privately owned by private individuals. So the net result is because of the checkerboard on the surface and then the split estate ownership where the federal government may own the land but not the minerals underneath, by restricting this access, you are restricting private owners from accessing their property. You're disenfranchising them. In essence, a taking with no compensation. And so in this draft management plan, that's exactly what you're doing. You are stranding private owners' mineral rights and denying them their ability to receive very significant revenue for their minerals. So please explain to me how that is in any way reasonable or fair to do that under this type. I mean, how can you do that in a resource management plan and in any way, shape, or form believe that that is fair and equitable?
Senator, thanks for the question. A resource management plan, of course, is about land and mineral allocation. We've issued the draft. We are hearing the comments, and I look forward to reading your letter. I don't think I've seen it yet, but I will find it and read it.
Would you agree, though, for example, if you were the owner of whatever property rights and the federal government was preventing you from utilizing those in full compliance with the law, that would be an unfair taking?
Senator, I am not an attorney, but what I do know is...
But then just on the common sense and just common sense fairness. So, I mean, it's your neighbor, you restrict your neighbor from the use of his property arbitrarily. Is that a fair or a reasonable thing to do? Just in general.
Yeah, Senator, I hear your frustration. What we try to do is balance the laws and the objectives of the administration.
But the laws require multiple use on these federal lands. So whether it's this resource management plan or your recent April 18th rule regarding public lands where you are now putting in place restoration or mitigation leases, okay, which lock away the ability for multiple use. Once you've put these mitigation leases in place, and we don't even know for how long, now that's limited to one use. That violates the law of multiple use. So on the one hand, you've got an unreasonable taking, and second, you're in violation of the law that requires multiple use. How can you go down that track and say that you're either being fair to people or complying with the law? You're doing this through executive fiat. You're not adhering to some new law. There was no law passed that suddenly said you can abrogate all fairness and former laws or laws on the books. There's nothing that says that. You just through executive fiat are blowing right by the absolute requirements of the law.
Senator, with respect, mitigation leases won't be single use.
Oh, really?
Yeah.
Tell me about that. So you're going to allow farming, you're going to allow energy development, all those things on these mitigation leases? So because I'd like to see that in writing, because that'll be great. I want to see that in writing from you.
It is in the rule that there are often overlapping uses in what we do. So, for example, there could be a grazing permittee who's got a grazing lease on a piece of ground. Mitigation company wants to come in and say, hey, I'd like to improve your grass. Can I work with you? Can we put a mitigation lease on this? They come to the BLM and say, we'd like to do a mitigation lease. And so those uses then become compatible. Transmission line across the section, for example, can be compatible with the increased production we're trying to get to through the mitigation.
We'll want those assurances from you in writing, and so we'll want you to come out and explain that to our ranchers and to our energy industry, to our tourism industry. We truly do have multiple use in compliance with the law, which benefits everybody, and we're going to want your commitment that that can continue.
It is exactly what the rule envisions.
Senator Hawley.